At this time, board staff will present the annual enforcement report. This is an information item only and no action will be taken. The item is being presented not just to provide a status report on enforcement. Staff is looking for comments from board members on the direction and priorities for enforcement in the region. Following the presentation, interested parties will be allowed 3 minutes each to address the board. We will now begin with the staff presentation.
Thank you, Dr. Longley. So Chairman Longley and members of the board, I'm Andrew Altavogt. I'm Assistant Executive Officer here in the Rancho Cordova office, and I'm here today to present you with an update on enforcement activities in the region. And so I'll also be giving you background on our enforcement program, a summary of our efforts, and I'm going to raise a few questions and hope to get input and some discussion from the board on our overall approach to enforcement. The first thing I wanted to note is that the bulk of this presentation was assembled by Robert LaRue, our enforcement coordinator, who you met earlier. And in subsequent years, he'll be the one who will give this presentation to the board. And then the second thing I wanted to mention is that Chris Kerrigan, the director of the State Board's Office of Enforcement, is also here, and he has a brief presentation that he'll also give you on some statewide issues and other things that are concern for the region. So I just wanted to put these questions up to begin with, just to maybe put them in front of everybody before before I launch into the bulk of the presentation. But these are the questions that I thought of to try to get some input on, and obviously I want the presentation as much as possible to foster some discussion, and I'll put these questions up again at the end of the presentation. So in terms of just brief background, the enforcement actions under the regional boards are, of course, governed by state and federal laws, namely the Clean Water Act, the state's Port Cologne Water Act, and then the regional basin plans. And so those are the three main legal authorities which govern our water quality permits and then provide the basis for our compliance and enforcement efforts. So in terms of staff resources, I'm going to start with that. In our region, we've identified out of our 222 approximately staff, 111 of them have been identified as performing at least some compliance or enforcement activity. And overall, if you break that down into the resources, the amount of time spent on compliance and enforcement, it's 23%, approximately a quarter of our efforts go into compliance and enforcement, with the other resources or all the work that gets done in planning and assessment, permitting, and then administrative work for the region. And so in both the Fresno and the Rancho Cordova offices, and then to some extent in the Redding office, there's a split in many of the programs, so that in many of our programs, the people who do permitting are separate from the people who do compliance and enforcement. And this was a split that was begun approximately 6 or so years ago. And the other thing I wanted to mention with this is that we do have some discretion in terms of how some of those resources are allocated in some of those programs. So whether there's staff time is spent on compliance or it's spent on permitting, for example. This is just a really sort of high-level look at how the resources are divided up between and then within the three offices. And as I mentioned, and as you heard from Clint Snyder's earlier presentation, that especially in Fresno and the Redding offices, there are staff who wear a lot of different hats and maybe don't focus on just one program. And then there are of course staff who do work both compliance and permitting work. So in those offices, especially in the Redding office, there are a higher percentage of staff who then work on compliance issues. This slide is, I believe everyone's aware, but just to present a little bit of description on the split function between in our enforcement world, between the prosecution team, who is largely responsible for bringing cases to the board, and the advisory team, which of course provides advice to the board on the ACL, administrative civil liability, and other cases that are brought before them. So the prosecution team is led by the lead prosecutor, which is myself, sort of transitioning, as I believe you know, from the executive officer. And then the assistant executive officers in each of the offices are responsible for the enforcement activities of their office as well. So in Reading and Fresno. Below them are the enforcement staff, and then of course the Office of Enforcement provides all our legal support and related advice and help with that. And as I mentioned, the prosecution team is the one who brings the actions to the board. The advisory team, of course, is the board advisor, which is, of course, transitioning so that the executive officer will be the board advisor, and then the technical staff who support the board advisor, and then the Office of the Chief Counsel, who acts on the advisory team. And so the split, of course, is in place to assure that there's fairness in our enforcement actions for the dischargers. And both teams are in service of the board, which is important to reiterate. But because of the split, the members of the two teams don't communicate about any enforcement actions that are coming before the board.
Can I jump in quickly? Is there a recent court case, though, that kind of questions whether or not, I guess I'll back up a little bit. I know that this is, in theory, the way it's supposed to work, and I believe that this can work and actually does work. So I think that this is intact. However, I recently heard of a court opinion that
Right,
that
and I
said-
asked Chris about this. Chris,
Okay.
maybe it's a time now just to address that.
Yeah, and you,
There's a case out there that's a Superior Court case I think it's called Blue Diamond Almonds. And so as a Superior Court case, it establishes no precedent, no binding legal precedent. The case involves very different facts than the way our program works.
what county is that in?
It came up in Sacramento Superior Court, and essentially in that case, the enforcement officer who was deciding hearings was directly funding programs in his office with the penalty money. So it's absolutely nothing like the way the water boards work, where the penalty money goes to the cleanup and abatement account, where a completely different body allocates that money in a different way. So Michael Lawfer and I and the Chief Counsel's office, my office, have been aware of this case since it was decided. We've looked at our protocols, tweaked them a little, but for the most part, the case is not on point and is not binding precedent.
Good, thank you.
So speaking of the Office of Enforcement, so the role of the the role of the Office of Enforcement, that is to provide legal advice and representation to the prosecution team in our enforcement cases. So the OE acts as an advisor to the assistant executive officer, and the assistant executive officer is the one who makes the strategic decisions in the cases. And then attorneys are assigned to each of the cases that are going to be brought to the board. And then also the Office of Enforcement has attorney liaisons who are assigned to each regional board and help with some of our prioritization, participate in monthly enforcement briefings that we have, and help to provide other advice and input. And for our region, we actually have 3 liaisons: David Boyers, Mayumi Yakamoto, and James Ralph. So the overall goal of the enforcement policy is to provide fairness and consistency while still allowing us to recognize the unique facets of any individual case. So, and then the overall goal of all of our permitting and compliance activities is to work cooperatively with the dischargers and others, both formally and informally, to make sure that water quality is protected and that the permit requirements are met. And as I'll mention as we go along, the bulk of our enforcement activities are in fact informal communications that are really aimed at working with dischargers, seeking clarification on issues, and solving problems. So in order to meet the legal requirements and the goals contained in the region's basin plan and the applicable state and federal laws, we need to, of course, make sure that permit requirements are complied with. The permits are tailored to address specific water quality issues and to protect beneficial uses. And in general, for almost all of our programs, we depend on the dischargers to perform self-evaluations of their performance and then report back to us. And so, this is our overall approach, working generally cooperatively with dischargers. But of course, we do need to make sure that we have a structured and rigorous enforcement program to determine both the levels of compliance, track the activities of the individual dischargers, and then to take action if there are violations that occur. So the overall goal of the enforcement policy is to protect and enhance the water quality of the state, and to define a process that addresses water quality problems in the most effective manner. And it also then provides specific guidance on administrative civil liability actions and establishes the concept of using enforcement as a deterrent to future violators. So in terms of the specific pieces of the enforcement policy, first of all, it establishes a process for ranking enforcement policies that's based on the actual or potential impact to beneficial uses or to the regulatory program, and it of course it highlights the approach of using progressive levels of enforcement to achieve compliance. It also establishes, as I mentioned before, a specific liability assessment methodology for administrative civil liability actions that is intended to create a fair and transparent and a sort of consistent statewide approach to the liability assessments. The third thing it does is it recognizes the use of alternatives to assessing civil liabilities, such as supplemental environmental projects that we heard some about earlier in the day, and then provides the standards for approving these alternative assessments. And then the final thing that it does is it emphasizes sort of recording and collecting of data and communicating the enforcement information to the public. So that's sort of the background on the policy itself. This is really just meant to be a visual representation of that methodology for determining the administrative civil liability penalty amounts. And I'm just sort of showing this to highlight both the number of inputs that there are to the overall process, some of which I know when we present our administrative civil liability cases to the board, we go through, in general, we go through at least some of this, but this is sort of just gives you an idea of the overall methodology. And again, it's really aimed at trying to assure consistency while at the same time getting the unique circumstances of each case accounted for. And then this slide just presents the overall workload of all of the programs in our region. And so it really just summarizes the numbers of permittees, general order enrollees, and others that need to be monitored by our compliance and enforcement staff in one way or another.
But in fact, that may not be somebody that you enforce against. Is this correct?
That's correct.
Yes.
Yeah. And so the only other thing I wanted to just add on this slide is that much of the work involved in this actually revolves around reviewing reports that are required and doing things like that. And so staff does a lot of work in terms of reviewing required reporting that comes into our offices. So this pyramid roughly kind of shows the breakdown in the types of enforcement tools that we utilize. And so on the very bottom of the pyramid are informal actions, and I'll go into some more detail on what some of these are as we go. And then but the numbers on the right-hand side are the totals for each of those types of actions from 2009 to 2013, so 5-year time period, that 5-year time period. And the first thing to note is that the pyramid sort of shows, if you look at the numbers, that the vast bulk of our actions are informal actions. And then the sort of the next tier, so below the red line are the informal actions. Above the red line are what are considered formal actions. I'll talk a little bit more about the notices of stormwater noncompliance, which are a little bit unique. I'll talk about those a little more in a minute. I also wanted to point out that you can see that there are 363 administrative civil liability actions that were done in that time period. 224 of those were for assessments of mandatory minimum penalties under our NPDES program. So that's something that we don't have flexibility over. And then the balance of the administrative civil liabilities, or 139, are the discretionary actions. And among those 139, I wanted to further point out that most of those get settled without coming to the board. So, and in that 5-year time period, there were 24 ACLs that were contested in front of the board. Oops, and this is supposed to come at the end. I'm not quite there yet, sorry. I'll come back to it. Evidently, I didn't quite get that structured correctly. Just a reminder. I'll have to page back when we get to the end. This slide just shows the informal actions only, and there's some variability throughout the years, and the informal actions are verbal communications, which is these things are defined in our enforcement policy, but there's a little bit of flexibility in what exactly they are. Staff enforcement letters and then notices of violation.
And I presume a verbal communication is, excuse me, memorialized with a memorandum or something of that nature?
No, it may not be. A verbal communication may just be a phone call to a discharger. It may be when staff is out inspecting a site, they just
But
talk
is this internally?
It is tracked, yes.
Okay.
Yeah, so we have they get entered into our tracking system.
Right.
Yeah. So then this slide then focuses in on the formal actions over that same 5-year time period. And the thing I wanted to point out here, if you see the largest portion of each of those bars are the notices of noncompliance in our stormwater program. And I just want to explain a little bit about that because since they do form the bulk of them. And those are mandatory actions, and that are exclusive to the stormwater program, and they're required under a 1998 Stormwater Enforcement Act that requires each regional board to provide notices of noncompliance to stormwater discharges for specific violations. And then in addition to that, there was a change where prior to 2009, the water boards only required annual reports for industrial stormwater sites, and beginning in 2009, that the water boards began requiring annual reports for construction stormwater as well as for industrial stormwater. So, and then the increase in these notices of noncompliance is in 2012 is representative of the increased enforcement actions against some of the stormwater discharge as that program was starting to ramp up some more. And I'll point out that there's actually a similar increase in the administrative civil liabilities for the same reason. You'll be able to see that on the next slide a little easier. So this is the same data that was presented in the prior slide, just removing those notices of noncompliance. And there are just a couple things I wanted to point out here. And again, you can see in this slide, and it makes it a little more clear, the bulk of the remaining formal actions are investigative orders, or what we refer to as 13267 orders. Prior to 2012, most of those orders, or at least in this time period, were in our dairy program, which again was a relatively new program, and as a result, we were having to use these orders to try to get information out of people who were new to the program, essentially. And then there was a sort of a further spike in 2012 with those orders. We had some problems getting industrial stormwater dischargers to comply with some of our reporting requirements, and so there was a push in 2012 to actually, when we use these 13267 orders, to get better reporting, to ask them formally for their reports and get those reports in. And actually, and then the reason it goes down in 2013 is because that effort was very successful, and basically the result of the work in 2012, asking for all of that, was that the next year in 2013 we had 100% compliance in terms of getting those reports back. So that's I just wanted to explain why some of those numbers had changed.
Andrew, I just want to point out, I think we need to investigate the 13267 number. That's incredibly low. So there's something going on with CWIX.
Okay.
So
Yeah.
I just had one question about, very often for one discharger that we might be issuing, through the progressive enforcement plan policy, first, different levels. For each individual discharger, are we talking about the highest, like the ACL? If it gets up to the ACL level, are we, if let's say XYZ discharger has first a time schedule order and then a cease and desist order and then an ACL, are those all separate items?
Those would all be counted
They're all
separately.
counted separately?
Yes.
Okay.
And then this slide just breaks it down in terms of each of the programs. And again, you can see that, sort of for the reasons I explained, the stormwater program has sort of the bulk of the action there. I think that's all I wanted to really say about that.
Just when we look at the differences here, a little over 1,000 an example for CAFOs and dairies, and then a number that is around 4,200, 4,300 for stormwater. The amount of PYs that are involved in this, are they proportional, or is the stormwater, that's a huge number. I mean, it looks like from this, they're really sucking resources.
No, and so that does not match the sort of the person resources, right. And part of that is because a lot of the, like under in stormwater, a lot of the enforcement actions were, I guess, on the form of letter writing and that sort of thing, which doesn't take nearly as much staff time as some of the work in the other programs.
2009 formal.
Yeah, and some of those were those notices of noncompliance,
Okay.
which in other programs a similar letter might not be considered a formal action. Yeah.
Dr. Longley, if I might, Ken, on some of these too, like the industrial construction stormwater programs, the permitting is actually handled by the state board. So in terms of staffing, we're only doing the compliance and enforcement. For like NPDS, we're doing both. Now, the permitting's not on here, but in terms of looking at overall staff, some programs we have permitting and enforcement. Others we have only the compliance and enforcement staff in the region. So,
Thank you, Ken. Any, go ahead.
On the
Yeah, go ahead, Bob.
irrigated lands program, I don't see that here, but I'm thinking all the 13247 letters, those were just information gathering and weren't considered enforcement then, or? And then the management plans that are done as a result are information, or they're not enforcement per se.
well, the actual develop the documents that we get as a result of those enforcement letters. That's just, we don't document that
Right.
in this, but the 13267 letter that required it should be documented in here, and I'm beginning to think that maybe that's where it's missing. I'm
Because
not
we've
sure.
done a couple hundred of those,
We've done a number of them, that's why I'm concerned.
or thousands, I don't know.
Yeah, I think part of the issue, and we actually kind of struggled with getting the numbers as they are in here, is the way that we can get the out. So all that information gets recorded in the CWIC system, but pulling it back out is more of
that
an art.
explains.
So
Apparently irrigated lands, because we don't have individual growers, that they're not entering the data into CWIX yet, so we'll have to see about remedy that
It
information.
would be nice just when we have it by program. I mean, maybe it tells a good story, we should have that.
I agree with you.
So they're not putting that into the LRP data into CWIX.
I think maybe Robert can answer it a little better.
I'm not entirely certain, but it could be being captured by the 8 coalitions. So there could be, for example, 8 enforcement actions. But I'm not entirely certain on
But
that.
each letter, I think, should be a separate one.
I don't think we have individual growers in CWIX, and we send letters to the individual growers, not to the coalition. So that's why we're not seeing the information.
You've
in
got something to
CWIX.
resolve, obviously.
But obviously, it doesn't have to be in CWIX, so we can amend
Right,
these data
right,
points
right.
and get the information from the program.
Yeah, and I think just because I think it probably tells a good story that we should have it in here too. I'm sure there's a decline in the numbers.
I
of
apologize, because I kind of skipped over that portion on the state of the region because I thought it'd be included here, so it was just missed.
So, on to success stories. On that note, there's just a couple things I wanted to point out, and most of these are actions that I believe the board may not be aware of, things that were resolved outside of coming to the board. The first thing is actually a pretty major effort that we undertook beginning in 2006, which is addressing a backlog of mandatory minimum penalties. So in 2006, through the work of the Office of Enforcement and the State Board, there was an initiative to try to eliminate what was then a backlog of more than 12,000 MMPs that hadn't been assessed statewide. And of those 12,000, 7,000 were in this region. And so over that time period, we got all of those MMPs addressed, and we're now, so we've cleared that whole backlog for Region 5, and now we're addressing all of the MMPs that come in within 18 months of the occurrence of the violation. So within 18 months, we send out.
Can I just make a slight correction? Region 5 initiated the initiative before State Board made it a statewide initiative. I want to give us the kudos. Wendy did a great job, so we initiated the effort here before State Board started. State Board did a great job, though.
We're good. We collected a lot of money. We're current, so Region 5's done a really great job staying current.
And I think that that's important also in terms of fairness to the discharger. So I appreciate it from that standpoint.
Yeah, and one of the results of that, of course, is then dischargers, when they're assessed, are getting much smaller penalties, which does make a difference. The second thing is North State Recycling, which was located in Shasta County. They had numerous problems related to both groundwater and stormwater issues. The board staff have been working with them, and they've seen big improvements in their what they've been doing on stormwater management. They've also implemented employee training related to stormwater management, and they've been working on other issues at the site, including disposal of a lot of aluminum ash that was on the site, and so that's been a real positive thing. The third bullet there is there's related to four abandoned mines that were owned by the Mining Remedial Recovery Company, which still have eliminated all fish from West Squaw Creek because of the discharges from those abandoned mines, and also caused fish kills at the confluence of the lake with confluence of the creek with Shasta Lake. So, but as of 2013, all the point sources of those discharges have been stopped. It's reduced the copper concentrations in the creek from 3,000 parts per million down to 100 parts per million, and there haven't been any fish kills in the lakes since that time. The fourth one is related to the city of Fresno and their wastewater treatment facility. There was a large spill, a spill of 200,000 gallons of undisinfected secondary effluent in June of 2013, and it spilled from their reclamation areas onto public roads. There were cars driving through it. There were sort of hazardous conditions, public health issues, of course, associated with that. And after the initial cleanup, the city has been working with staff and improved almost all of the berms around their reclamation areas, and they've also spent time revising their spill prevention plans and improving their spill response time. The Equilon was a site where there was petroleum degradation or degradation due to petroleum at a refinery in Bakersfield. And once staff became engaged with them, they responded by really getting on top of the site investigation and remediation work in a much more serious manner than they had in the past. And there was an ACL order that was issued in November of 2013 for $500,000 with $250,000 going to 2 SEP projects. And so that was also a success, getting money to SEPs. The fracking, there's actually, I'd hoped I'd be able to say a little more, but there's still some ongoing things there. But we issued a 13267 order that was successful in getting us some information that allowed us to get that information. Sorry. And then the last one was a matter that was in front of the board in October, which was the Rockland Crossings, which was for violations related to a stormwater discharge. And resulted in a penalty of $190,000 for that discharger.
So, not to be cynic, but how is that a success story? I mean, the action happened, they were in violation, we investigated, we sort of closed it. That seems to be different than the city of Fresno, where there was berms built, and I was just asking.
Yeah. I mean, it is different. I think one of the things that we believe has resulted from that is that there are now dischargers and folks in the industry who are taking our stormwater regulations more seriously, and I think that's actually something that staff have seen. I don't know if we can say it's a direct result of that, but staff has seen that. Of course, there's been less rain this year as well. So
And yes, there's that. And we've had some very significant fines in the past against stormwater dischargers, so I'd go a little light on your statement. It seems to be a reoccurring issue, and they keep showing up in front of us, and I can think of several.
So
One of them ended up being referred to the AG. So.
I agree with you, Dr. Longley, but we have thousands of sites, and a few well-placed ACLs in the beginning of the wet season has a dramatic response in the construction industry.
Gets back to what I'm saying. But I love that. Well, a few well-placed ACLs at the beginning of the wet season.
Well, it
It's a
does
strategy.
work. I mean, it is because they impact our environment, but it is
No, it prevents discharge.
and especially after such a dry period, because they become complacent in the field, and then they expect you that it's a surprise if it rains in the wet season. So.
Yeah, well, the earth is a sponge right now, and we may not see much of that this year. That doesn't mean that we're successful, it's just the weather. So.
I was going to ask a question, but I'll hold it till the end.
okay.
Okay, I'll ask it now. So, do you know about what percentage of the total ACL fines that we put out there, how much we actually collect? Do you know if it's 50%, 80%,
Good question.
100%?
I'm not sure of that.
Okay, that's why I was going to hold it till the end.
And I would provide some feedback from this because I think we've been involved in chasing down some of these outstanding ACL amounts, and I would say that every once in a while a really big ACL amount could skew that percentage. I think a lot of the individual actions are being collected. Some of our worst actors are the ones that get the big fines. They tend to be the ones that are not paying. There are exceptions, of course, but I think that so a percentage dollar figure would probably be skewed. We do have a good track record of collecting, individual actions, but even the ones that don't pay us, we go through the procedural steps of levying liens on property, things of that nature. We may not get paid, we may get paid cents on the dollar, but we are following up with those as well.
And I'll just add to that DAS, excuse me, at the state board has just engaged in a protocol where they actively start collections within 30 days after the amounts become due. They have a collection agency that's going to be under contract that will go out. And so DAS is taking it upon themselves to become much more diligent about timely collection and prosecution of actions. We've had a real difficult time getting the Attorney General's office to assist us in court on collection actions under $75,000. And so consequently, I recently negotiated an agreement with them where we're allowed to take actions without the AG's office on matters under $75,000. So this is an issue that we've identified as something that we need to follow up on. We need to be making sure that people who can pay do pay, and if they can't pay, it's because they're bankrupt or have no assets. And so both DAS, our office, and the Chief Counsel's office are really engaged in that effort.
Chris, there's another issue too, and that is after a board, whether it's this board or another regional board, passes an ACL, and it is petitioned to the state board.
Yeah.
The timeliness of that.
Yeah, I understand. So the state board actually has, and this is probably what David was going to say, they have draft regulations on petitions for review, which we hope are going to affect that in a very positive way. I've already submitted a letter of support. It basically means that these ACL actions where there really isn't a cognizable defense that the state board wants to consider as a matter of a statewide precedent or something of that nature, those guys are going to get passed straight to Superior Court and have to file a lawsuit real quick. So we're not going to have hopefully the regulations are designed to avoid these very long delays while things are petitioned for review and nothing happens.
And if they get past the Superior Court, that means then their fine is due, is that correct?
Well, they have a chance, if you get past the Superior Court,
They got to
have
go into court to get
30
it.
days to take a writ, and that means you got to hire a lawyer, go to court and challenge the decision, and then if you win, the fine's going to be reversed. But there's a very small percentage of these that are actually going to get taken up on a writ. It costs, in my view, it costs very little to file a petition for review with the state board. When you file a writ petition in Superior Court, it's time to put up or shut up, and I think most people will shut up.
And this isn't meant to underscore DAS's efforts at all. I think they've done a very good job. If anything, they've been a little overzealous in actually sending out, bills to folks that have actually filed petitions.
David, they cannot be overzealous in that.
Well, statute.
That's an accounting issue.
Yes, that's an accounting issue, not a legal issue.
Yeah, I mean, if people are showing up with crowbars and, in the checkbook, that's different.
So the last thing I just wanted to touch on were what we see as some of the emerging issues, or at least sort of some of the emerging programmatic issues. The first, as we sort of touched on a little bit, is irrigated lands. I think we see as the coalitions start the permits start coming into effect, that we're going to be looking at making sure that all the growers who are supposed to are either enrolled with the coalition or have their own, are enrolled in the individual permit. And so that's something that as that program gets, starts
I
to
have
get
a
off the
generic
ground.
question on that. Let's say that we've got a number of coalitions out there, and we're hearing in the South that one coalition may be morphing into several coalitions. And if a coalition, whichever coalition it might be, decides it doesn't want to exist anymore for one reason or another, what is our strategy on that?
In terms of enforcement,
Yes.
I'm not sure that we haven't discussed a strategy on that as of yet. So I'm not exactly sure what that would be.
What do you mean by, I don't know exactly what you mean
The
by
coalition,
strategy.
there is no coalition for that
So
area.
we regulate each individual grower in that area.
And
And the strategy is if they don't comply, we enforce.
and you will do that post haste, I take it then.
Well, we'll get out there and put everyone under notice that they need to file for the individual
For the
order,
individual.
yes.
That's what I want to hear.
And so,
Thank you.
Yeah, absolutely.
on the irrigated lands program, the question I had was, each coalition is sort of, I know they have their own rules for when they have to tell us that somebody didn't participate, but I can see their informal bar sort of bouncing around, especially between. So how have we thought about that? Have we given them guidance on where, when, and where they should?
The irrigated lands program?
Yeah.
And the coalitions, they don't do any enforcement. They are required to notify us every year of who's in and who's out and the reasons for why they're out so that we can pursue them for.
But aren't they the ones that are keeping track of whether or not someone attended a meeting, or the training, the annual?
They have to report that they've done their required training and reporting.
I'm just.
But we take all the enforcement. But they just report the data to us.
Okay, I guess my concern would be that the coalition would wink and a nod to say next year, make sure you didn't do it this year, but next year, make sure you come in. And those kind of things are going to happen at the local level because, I don't know, maybe not, but that's the question,
Well,
how we're overseeing that.
No, you can't speak.
A quick answer to that, I think, is the fact that the coalitions conduct a lot of monitoring, and there's no winking and nodding as far as that's concerned. So if they report a water quality issue, if they see some high pesticides, some high turbidity in a waterway that they're monitoring, that's really what gives us a signal to go in and check out who's in, who's out, where is that pollution coming from. The coalition has to formulate a plan. If we don't get that plan across our desks, and even in cases where we do, our inspectors are looking at that water body for enforcement purposes.
He's talking about the less water quality related reporting and the reporting of them attending any kind. So if we have reason to believe they're lying to us, then we'll have to find a way to investigate and do a truth-finding mission, which we've done before with other dischargers. We'll conduct audits or whatnot if we suspect that that's happening. But so far we haven't investigated. We've actually, it's amazing how many people will tell on each other. While we can't give names out, if the coalition isn't doing a good job, we'll hear about it from growers.
And is any function that the coalitions do, including reporting who's a member and who's not a member, can that be considered to be regulatory in any stretch of the imagination?
That's a legal question. I don't think so.
So I'll ask Patrick or David or Alex. Alex, go ahead.
Well, if I was a little unclear on the
Well,
question
the
about
way-
regulatory. I mean, we've tried to say that the coalition is not responsible for enforcing this permit against its own members. And, in that sense, if you're using the sense of the word regulatory as to have a
Yes.
relationship between overseeing compliance, that role falls to the regional board. And the coalitions are primarily viewed as our liaison between the board and the individual
Good.
growers and their representatives.
Bob, you
No,
have,
I just want to add, I think, and, you know, I work mostly in portions of the Sacramento Valley, and you don't want to necessarily extrapolate that experience throughout the Central Valley, but, I mean, it's to all of the farmers' benefits in a number of different reasons. One is if they're all enrolled and they have a self-interest in that, then everybody's cost is spread over everybody else, so nobody's getting a free ride and an advantage. So there is an interest in ensuring, you know, they have 100% enrollment because of that. And the monitoring, as Patrick referred to, that's like pretty strict. And, you know, and then the cooperative management plan to get work done when problems do arise. Again, that goes back to full enrollment. And I think it's just, it's set up well that it's in the farmer's self-interest. And I think what's another important thing about that is it makes agriculture somewhat defensible in terms of we're all involved, we do our monitoring, we know when we're part of the problem and when we're not. And so there's big advantages and incentives for participation. I mean, sure, it costs money, but, you know, that's the disadvantage, I suppose.
well, no, that's part of the cost of doing business in a very sensitive environment.
Well, Dr. Longley and Member Costantino, your questions, I treat this program almost similar to like what we do with the MS4 program, the large non-point source program. That's now a point source program. But, you know, we once we got the program established and in place and the communities doing their things that they were supposed to do, we started to conduct audits. So I imagine as part of our overall strategy is once we get it settled and the coalition's running the show the way the order requires them to, we'll start conducting formal audits.
Thank you.
So the next thing on the list isn't necessarily so much an emerging issue, but it's just a continuing issue, which is looking at dairies. Obviously, we've had a couple cases of dairies recently in front of the board, but there's a lot now that we had for a while a backlog in our inspections with our dairy program. Again, we've caught up on that backlog, and as those inspections are caught up, we expect that there may be some more enforcement actions coming. The third thing on the list is mines. I put that up there because they're currently scheduled 2 cleanup and abatement orders for mines for the March board meeting, and I wanted to mention that staff have thought to start bringing some of those to the board, the cleanup and abatement orders for the mines, to have the board weigh in on the issues surrounding responsible parties, which often for mines can be somewhat complicated, and so that's something that we've thought to do. The annual stormwater reporting, again, this is one where there's sort of some new facets to the program where especially for the construction stormwater, they're required to submit yearly reports if they're enrolled in the program, whether they're building or not, and so that's something that we're going to have to stay on top of some more. Marijuana, again, I know you've heard updates from Clint Snyder at previous meetings, and I believe that he'll be coming to you at your March board meeting with some more details on that program, but that's certainly an emerging issue for enforcement. The fracking and oil extraction, again, that's sort of a continuation of some of our current efforts, but also there's SB4, which was just passed into law, which has some new requirements for us, working with other state agencies. That'll, I believe, will lead to more different types of enforcement actions in those programs. And then the last thing to mention, which you had heard about this morning, was our proposal to work on bringing a programmatic SEP proposal to you. So those are the emerging issues, and I think that was it. And I'm going to have to go back and find my questions. So these are the questions that I thought to ask the board. So what are the areas that the board believes we should focus on? Is our general approach in terms of progressive enforcement, that sort of thing, in terms of the numbers you're seeing, do you believe that that's on the right track? And just, are there any other areas that you would like to provide us guidance on?
And if I can step in real quick too, Board Member Ramirez, you asked a question about separation of functions earlier. It actually wasn't the Blue Diamond case that's been kind of in the news recently. Blue Diamond is a case that we're watching closely, but the one you are probably talking about, and you've heard it mentioned at a few ACL hearings over the past few months, a case decided in about 2013, dealt with what are called Howitt factors, and the Howitt basically says that performance of both roles by the same law office is appropriate if there are assurances that the advisor for the decision maker, which is you, is screened from any inappropriate contact with the advocate, which is generally the Office of Enforcement. And that's what was decided. Yes, that is appropriate for government agencies. Morongo at the Supreme Court, and California Supreme Court decided that. So that issue is settled. We were heavily involved in that litigation. But the Howitt rule has only been applied to government lawyers. There was a law firm that got themselves in the crosshairs last year, Saby versus City of Pomona.
And that's the case. Is
And
Saby.
that's the case that you, yeah. And essentially the law firm was contracted by the City of Pomona to fulfill both the advocacy and advisory roles in that we and OE share. And the court said that was improper, but specifically because of the fiduciary duties that the partners owe each other. So if, say, an OE attorney and myself had a fiduciary responsibility to each other, it would be improper. We'd have to go somewhere else to decide that matter. But that is a case that gets brought up a lot because it kind of looks like what we're doing, but OE and myself and Alex and David, there's absolutely no fiduciary responsibility. So Howitt is still good law. Morongo is still good law. No issues as far as separation of functions I see.
And that's good, and that's comforting because I know that, entities try to bring that up. I know in motions, I don't know if they're motions in limine, but motions to the chair before hearings and argue case law, and if it's not relevant because of the lack of fiduciary duty, then it's easy to discard that because I've seen what happens, and I think that that separation of roles is intact. So thank you.
Andrew, can you go back to the flow chart? Yeah, that one. Thank you. So a couple
John, don't do that.
a couple of the issues that I think we've had over the last year have been on the culpability, because that's you can multiply by a factor of 3 there, and I'm trying to find it, the economic benefit. I'm not finding it here, but I'm sure it's there somewhere. Oh, there it is, page 20. That seems to have been, I don't want to say a weak link, but it's a question where it's come up quite a bit, and I think we talked about it after one of the items. The Air Resources Board has a whole economic unit. I think maybe we were limited on staff resources, possibly. So, there's a better way to do that economic benefit. If there's a better model, if there's some way to get that number a little more solid, I'd like to see that a little bit more. Okay. And then, on the part where you can add in the discretionary parts, there's beneficial uses, there's culpability, cooperation. I think we've been rather straightforward and consistent with that, so I don't really have a problem with that. But I know that's been on one of the cases. I think we had culpability of 1.5, and they thought that was precedent setting. So that was just an interesting place where folks try to poke.
Yes, John, if I could just add to what you're saying, basically I concur, but we get this presented to us as part of a case, the numbers are presented. We hear the issue, but at that point, it is somewhat difficult, if you will, to change the culpability if we don't agree with it. I know we can, but it just seems to stop the truck in the middle of the track and in the middle of the bridge. And if there was a way that, and I just throw this out for a thought, is there a way, or should we even be making a decision during that hearing on culpability and on some of these other issues that John brought up?
Yes, and it's very straightforward for the board to change the numbers assigned under each of these factors in the matrix. And there's a spreadsheet that the chief counsel's office has access to and your advisory team can use. I think it's important to resist the temptation to pick a number and then dial on the spreadsheet to reach that number at the end. But if you were to say, take the culpability recommended by the prosecution team at 0.75 and the board thought it should be 1 instead of 0.75, it's just a keystroke to make that change on the spreadsheet and then advise the board what the modification to the ultimate liability would be. So the board should feel free and unfettered to modify these numbers from either the prosecution team's proposed order or that advocated by the discharger based on its conscience and decision. And I'll talk a little bit about why it's so important for the board to do that when in my pitch here in just a minute.
All right, because I was going to comment on that too, and I was going to say that, you know, we can't forget that even though we trust staff, that they're an advocate for their position. So it's just their position that they're presenting to us. We're the decision maker. We decide whether or not the 1.5 is justified and whether we should dial it up or down. And just the way that the discharger is going to come and advocate for the lowest number as well. I mean, that's our call. So I'm glad that the feeling is that we should be able to dial that up and dial that down without stopping the truck. Because I think the discharger should know what the range of the penalty could be. But at the end of the day, you know, you're walking out of here, you may or may not get that same number when you leave.
I just want to piggyback quickly onto one of the comments that Chris made. Certainly changing the number is easy, and I'm cognizant of the board's sometimes frustration, but I also want to point out that if in fact the board decides it does want to change a number by a keystroke, generally speaking, that may also, in addition, require an additional finding or finding to depart from the recommendation. So it didn't, and again, I know Chris didn't mean to imply this in any way, but just
But the
to be
findings,
to be
but the
clear in the
fi-
board's mind that, you know, that
Right.
may result in,
And
you
I
know,
was
amending
and
a finding in the order, and it's
and
not
I
just a
was
quickly
aware of
function of
that.
changing a number.
And I think that maybe what stops the truck sometimes is what are, you know,
I don't think it is as hard, I'm sorry. Go ahead.
I think it's appropriate. If we're gonna make a change as the board, then we should let people know why we're making the change, and that's basically the finding. But, I mean, that's the board. First, we have to decide we wanna change our numbers, and that almost do the finding first, and then you can change the number dependent upon the finding, so.
Changing findings is not that difficult.
It's
and I-
not that hard, it's easy, I think, but
Yeah.
I think if, as a board member, if I wanna change that, I'm gonna give a reason for it, and I think that's the basis of the finding.
And that's a
And
finding.
I think is that what you're saying?
So, Member Ramirez, I just want to point out, you mentioned that staff was an advocate for their position. I want to make it really clear, we're not advocates. We're simply, based on our opinion and our recommendations, making that recommendation to the board. We're not advocating our position. We clearly understand the role of the board, and it's fully at the board's discretion to make changes to our recommendation. We're not advocating. I
Well,
want to make that really clear.
And I appreciate that. I guess in my mind, it does feel like an advocate, only because I know that it's almost like the DA's office, and you try to be fair, and you try
Right.
to come with with the evidence that either makes the person look guilty or maybe can exonerate the person. But at the end of the day, you know, if you believe, staff believes strongly enough in their position that they're going to bring it forward. So even though it might not be an advocate at all costs, it is sort of a position that is being offered.
I have to concur with Board Member Ramirez, with Dr. Ramirez, because.
Well,
No,
I do have a JD, so.
Because going back to the old days, there was a very definite relationship between the board and the staff, and with the split function, and I'm not condemning it, I think it's just natural, it comes with the split function. There is an advocacy role, period. And,
Well, Doctor, I gotta say, though, even with permit writing, staff doesn't want the board to change their recommendation. I mean, that's a personal thing. But that still, we are not advocates for those positions. We're simply making a recommendation based on our
well,
judgment.
we're going to have to agree to disagree on when it comes into the enforcement functions.
I make it really clear to staff that we're not advocates, so I want to make sure, I want the board to understand from the executive officer, we are not advocates. You may want to use that word, but we're not advocates.
And I appreciate that you feel that way and that that's the way you see your staff, so I appreciate that.
So, can I ask another question?
Go ahead, John. It's kind of dangerous territory out there, but go ahead.
Well, and it's not a question so much as the guidance. You asked, what do we think about things? And over the last couple of years, there's been a few items that have come before the board which seem like no-brainers. Either no-brainers that we're going to completely agree that staff did the right thing, and I can't believe it got here. I can't believe that the discharger thought they had a case, or the other way where the board thinks we were sort of overreacted. It's a big deal to come to the board. It's a lot of staff work. It's a lot of noticing, and they have to hire lawyers. So, and I know it is the minority. I know we settle as many cases as we can. But I would just throw that out as encouragement that, maybe there's some statistics you can show that for every case that comes before the board, 95% of them don't get changed more than 5%. And that might be something to sort of give the discharger to say, you can take your chances, but it's just going to add to the expense and and it's always up to them. But, the less we can have those sort of ones that don't have a lot of precedential value one way or the other, just sort of get them off the books, I'd appreciate it.
Yeah, and I mean, certainly our general approach is we want to encourage settlement as much as possible for a number of reasons. I mean, not the least of which is our staff time, and as you mentioned, it takes a lot of staff time to bring things before the board. But I think in general, the process is a lot smoother if we can come to some agreement with the discharger and move on then.
Having said that, though, I mean, I would like to be clear that if settlement isn't possible, we don't shy away from the hearings either. So they should know that too.
Absolutely.
That we're happy to take them and that Carmen really likes them.
So I'll skip this slide when I get to it, but this is something I wanted to address with the board during my short presentation. And that is, in our settlement considerations, we have a range of outcomes that we believe are acceptable within the interpretation of the policy. And the range of outcomes so we're not stuck on any particular thing, and we're not going to make a deal come heck or high water if we can't get that. We have a range of possible outcomes. If the discharger is reasonable on that range of possible outcomes, the matter's resolved. If the prosecution lead feels that the best proposal by the discharger is outside the realm of legitimate interpretation of the enforcement policy and what should happen in that matter, then we feel like it's up to the board to make that decision. And if we're wrong, we accept that, and as Pamela said, we're not advocates, we accept that and we learn from that decision. But I will say, in the last 12 months, all the enforcement actions that have come before this board, the decisions have been within the realm of possibility that we would have resolved the action but for the discharger's refusal to be reasonable. So when we're before the board, it's because we're outside the realm of what we think is reasonable, And if we're going to go outside the realm of what we think is reasonable, then we need the board to make that decision. And that's why we bring cases to the board. We have a pretty good read on the board, what is the range of possibilities in the cases that you've been deciding, although we may not be getting what we've asked for in the pleadings. We're getting a lot more than the last best final settlement offer from the other party. So
I would be curious to see, just along that line, because you had talked briefly, and perhaps you'll go into it more, about your proposed policy for anything that's under 75,000. Oh, no, actually, the cases that we hear that that end up getting petitioned to the state board, that the state board feels might not have a chance anyway, having to go to court instead, litigation instead. For those cases, we see them here. Sometimes it feels like, gosh, staff was right on. Why are we listening to this? And it's because of that. I would be curious to hear what happens to those cases. I imagine they might be settled, or I hope they'll be settled, because there will not be a chance for them to petition to the state board.
I'm not sure what will happen under the new petition regulations once when things happen. I personally have a pretty substantial list that I push Phil Wiles on all the time, saying these cases need to be dismissed. They present no unique issues. You got to dismiss them. And he's saying, wait till the new regulations go through. We'll get them dismissed, and then that way people will have their opportunity to go to court. One thing you also have to remember here is, and I'll give the example. I think you may recall this gentleman, Mr. Sweeney. Mr. Sweeney is a gentleman who will take advantage of his opportunity, his right, actually, to not settle a case, to be heard, to petition government, both at this level and probably any other level. And so you have to remember, too, that as much as the prosecution staff may want to be efficient and may want to resolve matters within the scope of the legitimate realm of the enforcement policy, there are some people that are there's always going to be some people who are going to want to stand on their right to petition government and feel that they're aggrieved even by the whole structure of the government, which I think Mr. Sweeney is one of those people. And I think that fairly characterizes him. I don't think he would be upset at me characterizing him in that way. So, there are those dynamics always at play in enforcement actions and how your staff engages with the regulated public in an enforcement action.
I have a question about the page 14, the pyramid. So I like to see that there's, the bulk of the enforcement action. I love progressive enforcement. So I like to see that the bulk of the enforcement action is at the bottom, and then we progressively move forward. I see a big bulge at the ACL level, and I just wanted to know why that is. I see a lot are MMPs, so I'm assuming that's that chunk, but there's still, I think,
Still
140
139, yeah.
Yeah.
So there's still 139, and so those 139 are discretionary. I mean, I think, part of it is some of the other tools. I mean, this is sort of going up in terms of, I guess, severity, if you will, and some of those other tools just aren't used as often, and there's some like the cease and desist orders, which are often used just to accompany a permitting action, to put or a time schedule order that puts that on a permitting action. And so and a lot of those, frankly, a lot of those discretionary ACLs are for things like failure to submit reports, and so they're the dollar amounts are relatively small. It's important that we do them so that we ensure that the reporting requirements are met and that those sort of signals are sent. But that's, a lot of them are going to be things of that nature.
And then there are others, like a case we heard yesterday, that for good reason needed to go straight to an ACL, and I completely understand that.
Well, and even in that case, and I think we did discuss this yesterday. I mean, we took a progressive approach, in that case as well, and it just.
Well, I think you made a very good point. This is an order of severity, but it's not a true progression, because as you get up to an investigative order, it may be a cleanup and abatement of what's called for, but you don't, or it cease and desist. When you look at it, cleanup and abatement may be inappropriate. And so There's really a disconnect there.
Yeah,
I
actually,
wanna-
I was going to make that, oh,
I want to reiterate what Jennifer said. There are at times egregious issues that arise of water quality degradation that should be jumped straight to an ACL. And, you know, I don't want our staff to feel inhibited that, oh, we always have to do incremental enforcement. I think our staff also has to evaluate is what is the degree of this impact on water quality, and at times feel that, yeah, okay, this is one, and I'm sure the executive officer can make these decisions. This is one that needs to have an ACL. It's significant.
That will now be Andrew making those decisions.
Thank you,
I-
Andrew.
I-
I'm sure you can make good decisions.
I just had one question only because I thought that maybe one or more board members may be interested or asking or thinking about the same type of question. This has to do in the context of discretionary ACLs. So of the discretionary ACLs that were issued between 2009, 2013, 100 and, don't ask me to do the math, even though I think Andrew just said what the number was and I already forgot what the number
139.
is. What percentage of those actually settled versus actually went to a board hearing?
Right, so of those, 24 went to a board hearing. The rest were settled.
And remember too, I'd like to remind the board, we had these mass dairy settlements for failure to have your manure management plan cases. Those were ACL cases, which were fines were in the $2 to $5, maybe up to $10,000 range. And we'd have settlement conferences scheduled for 2 days straight, out, hour after hour, where it was just like walk in and settle your case. And, we had lawyers on there and an ability to pay guy there on site to resolve those cases. And that, that accounts for, so we did batch cases like that on the dairy manure management plans, on the failure to enroll plans. And so those are discretionary ACL actions, even though we're basically just trying to pull people into our regulatory programs.
This is very informative discussion. The 75 minutes will be up in about 3 minutes. We still have to hear from Chris. I'm sure we're going to have some more questions. We're going to lose a board member in about 45 minutes. Has to go to another meeting. So we need to. I'm not asking you to hold your questions, but we need to be very concise, make good use of our time.
Thank you.
Thank you.
Thank you, Andrew. Now I am. Chair Longley and honorable board members, I'm Chris Kerrigan from the State Water Board's Office of Enforcement. And I just wanted to say I'm really pleased to be here to address this board on some of the more advanced topics in enforcement. And because you guys are really adept with the enforcement policy and the application of the penalty methodology. And even though Board Member Constantino had a few questions about it, I feel like you're adept enough with that flow chart that you can manage ACL actions. And so we're going to go to advanced topics and also talk about a few coming attractions. And I will try to be brief. And also, please engage me as we go. So I want you to know that the main thing that I've tried to do as the director at the Office of Enforcement really is to assist the regional boards with attaining their enforcement goals. To me, I feel as an attorney and as a public servant that this is my principal role as the chief in the Office of Enforcement. Enforcement happens at the regional board level. I work on policies with the state board, but essentially the main focus of our office is to help the regional boards attain their enforcement goals. We assist the regional boards with setting priorities, achieving maximum water quality benefits, protecting the public, deterring harmful conduct, but the main thing we want to work on is encouraging the regulated community to anticipate, identify, and correct violations. And as Andrew correctly pointed out, most of our work is in teaching people how to comply and educating them about how to work to protect water quality. But some of that means we have to use a hammer from time to time, and that's where our office can assist the regions in achieving their goals. I want to let you know a few things that we're working on now. One recent initiative that the Office of Enforcement is focused on is developing strategies with the regional boards for identifying nitrate-impacted groundwater and environmental justice communities that rely on that groundwater. Enforcement orders, we want to find areas where we can do replacement water orders or agreements. And although that's a small part of the solution to nitrate-impacted groundwater, it's something that we feel we need to be actively engaged in. We recently had a really good success story with clay in the Fresno region at a place called Rodriguez Labor Camp, where we were able to identify the basic elements of what we think is a successful approach to issuing replacement water orders. There we located high levels of groundwater nitrate, or nitrate in groundwater, in an environmental justice community that was dependent on that drinking water, an agricultural operation that was the only agricultural operation in the area, and that had been farming there contiguously for many years. And so it was a perfect situation to go in. Once we engaged with the discharger there, with the assistance of Clay's staff, we were able to negotiate a replacement water order that's going to benefit 200 people. It was an excellent success story, and it's one of the first. We hope to have many more like that. But again, as I mentioned earlier, it's a very small part of the solution to nitrate problems in groundwater. We've done the same thing in the Central Coast with the San Lucas replacement drinking water order that was entered down there. And then also I wanted to point out, Andrew mentioned this settlement agreement and SEP with Equilon. One of the SEPs that was funded by that was, with that penalty money by Equilon, was a new drinking water supply for the community of West Goshen, which is also a small disadvantaged community. So we're looking both to figure out areas where we can issue replacement water orders or negotiate agreements for replacement drinking water for EJ communities. We're also looking for ways to use penalty money to fund those types of projects. And again, you saw how the Rose Foundation may very well become a good conduit for that type of effort. The Office of Enforcement is also heavily involved in the development of our efforts at regulating the marijuana. We're assisting the regional boards with developing regulatory programs, with developing protocols and taking enforcement, with assisting the regional boards with outreach and education to the regulated public, and then also with coordinating with Department of Fish and Wildlife and local law enforcement, district attorneys and sheriffs, and then also with the Division of Water Rights. That came up very early in today's meeting. It's really important to integrate these things together. I want you to also know that the water rights enforcement tools are weak and cumbersome, and so it's really important to have an integrated strategy to address illegal or unauthorized diversions. If there's any way to bring water quality laws or fish and game and endangered species issues to the table, that gives us a lot broader tools. Water rights are fundamental usually. The procedures for implementing water rights enforcement are Byzantine and difficult to work with, and the fines and penalties are really low. So it's a difficult thing to go out and just isolate illegal diversions and try to take action based on that alone. In the marijuana context, fortunately, there are usually water quality impacts also associated with illegal diversions, and that means we can bring in those powerful tools that we have, like 13304, to issue cleanup and abatement orders, and if those cleanup and abatement orders are violated, to issue administrative civil liability complaints. So I'm working with Clint Snyder. I didn't even know Clint before this. No, I mean, I did know him. We worked on a few cases from time to time. But it seems like I'm on the phone with Clint every week. We're on the phone with Fish and Wildlife. We're trying to figure out how to develop protocols that will allow us to leverage our scarce resources in the most effective way. Clint's really done an incredible job leading the effort to coordinate with other agencies, and really on the verge of starting to get boots on the ground out there, I think. It shouldn't be too much longer until we are able to do that. So that's all I have for marijuana. I want to talk to you about, give you a few statistics, and then I'll tie these in why I'm giving these to you later. I want to talk about discretionary ACLs and what's been happening before and after the enforcement policy was adopted. Essentially, the trend is upward. We're doing more actions now than we were before the enforcement policy was adopted, more discretionary actions. And we're also gathering more funds from discretionary enforcement actions. And you can see the dollars are trending up as well since before and after the policy. Essentially what that means is there's more money going to SEP projects in the regions and more money being distributed from the cleanup and abatement account and a larger level of deterrence to the regulated public. So we're hoping that this has an effect on compliance. It seems as if our preliminary data indicates, at least in the NPDES program, where we have the most mature data, that it is having an effect on compliance, but we're still truing up the data. It may just be we have data anomalies in our program. So we want to make sure that's not the case before we come out. But certainly it seems as in the last 2 years, the violations in the NPDES program are trending downward, and we're getting better compliance rates. So I want to let you know that those kinds of things are going on in enforcement. We talked about separation of functions. We talked about it in some detail, so I'm going to go through this slide without comment. I wanted to talk about stipulated orders, and here's something that we started to touch on, but stipulated orders are settlement agreements, essentially blessed by the board. They're negotiated by the enforcement staff, and we go through the same exercise, the executive officer and now the assistant executive officer, Andrew, and the staff go through the same exercise as you go through. And we look at the various factors, and we make a good faith assessment in our view of what those factors should be. Then the discharger comes and presents its evidence to us and its position. And many times we reassess our position based on new information or based on a perspective that we hadn't considered. And as I indicated, there's a range of possibilities that seem acceptable. Hey, maybe culpability should be 0.2 lower. Okay, that's not going to stop us from reaching an agreement. Something like that. When we come in with something that's way lower or way out of line, then we're going to ask the board for assistance. And that's where it really is the board's job to make decisions that we think would be outlier, and that provides us guidance for the future. It provides us data about how the board perceives the different types of factors that are at issue in the case. So even though, as Andrew indicated, I think 24 times the board has ruled on contested discretionary ACL proceedings, that's enough data for the staff to have a pretty good idea what the range of possible outcomes in a discretionary ACL proceeding could or should be, and what we can do out there on the board's behalf. And again, if we don't settle a case, it's usually because the last best final settlement offer we got is out of the range of our comfort zone, where it's something that we just could not accept in terms of one of the factors or one or more of the factors or elements that's being analyzed by the staff. Go
Question.
ahead, John.
So a stipulated order, is that a settlement or is it different than a settlement?
It's basically all of our settlement agreements are more memorialized now as stipulated orders. Some of them may come to you on the consent calendar. Ken can sign them. Now I think that'll probably be Pamela. I'm not sure how your delegations will work out. But we always enter our settlement agreements now as orders. So that's the new protocol, because then they are enforceable as orders as opposed to as an agreement. Okay. We talked some about the alternative to assessing monetary liabilities like SEPs. You heard a proposal about the Rose Foundation SEP, compliance actions, compliance projects. This region is one of the best, if not the best, at assisting the regulated public, the small disadvantaged communities, with engaging in compliance projects. And of course, that's what we want. We want to have a future where water quality is enhanced. And if a small disadvantaged community needs a leg up, some financial assistance to make that happen, then we want to be able to make that happen. And again, I think this board staff does one of the best jobs in the state at making sure that those that need funding in the small disadvantaged community context are getting it, and for good proposals. Okay, so I wanted to talk to you about something that's going to come up here, and hopefully it's going to come up in a month or so. I've done a white paper and a study on MMPs, and essentially from 2009 through 2012, $20 million in MMPs were assessed. Out of that, $17 million worth of MMPs were uncontested. And of course, the statute says mandatory minimum penalties. So there isn't a lot of wiggle room or flexibility in the statute, and yet we seem to be having hearings on these mandatory minimum penalty actions with some regularity. Now that's 25% of the time. Water board staff spends as much or more time on the 25% of MMP actions that are contested as it does on the other 75% of the actions. So we looked into these statistically and came up with numbers. I have a white paper that I can circulate to the board if you'd like to look at some of the statistics and the backup for this information. But the important thing to think about here is that time spent on MMPs detracts from the board and the staff's ability to do high priority discretionary enforcement in other areas. And so we want to make sure that we observe fidelity or remain true to our statutory duty to work on MMPs, but we don't want to be enslaved by MMPs. So to that end, we're going to recommend that the board delegate its authority to hear MMP actions to the executive officer. Region 4 passed their resolution making that delegation at yesterday's board meeting. We've talked about this with the state board and with the chairs, and I think it's a good idea. I want to give you some information as to why we're making this recommendation. Three main issues with MMPs are that dischargers fail to respond to EPLs, which is early payment letters, or complaints for MMPs. They just completely blow it off. The dischargers challenge compliance determinations, and that's the technical staff's determination as to whether a matter is actually an MMP or not. And the third main issue with MMPs is that dischargers assert legal defenses that are not contained in the statute or that may not be allowed. So the MMP statute, the legal defenses are very narrow, and a lay person may read the defenses without really understanding what an act of God or act of war type defense means. What do you have to prove there? Well, it rained. That was an act of God. No, that was not an act of God. You should have been anticipating that it was going to rain. So I think that it's really important for us to be able to dispel myths about what is a cognizable defense, either technically or legally, in an MMP action. Some of the lost efficiencies in MMP actions when they go to hearing are that the board spends time engaging in the hearings. The board and the staff spends a really large amount of time preparing for hearings. My attorneys spend a lot of time preparing for hearings, and the staff and the attorney spend time addressing statutory defenses, and also the staff spends a lot of time engaging with the regulated public over compliance determinations. So what we're recommending is that the board agree to delegate authority to the executive officer to hold hearings and enter orders on contested MMP actions. We're also going to draft updated and standardized FAQs, frequently asked questions, and Q&As on compliance determination protocols, and distribute those widely so that the regulated public understands how we make our compliance determinations and whether to contest those or not. The last time those documents were updated was 2001, and we've come a long way since then in developing standard protocols with respect to how we make compliance determinations.
Chris, insofar as taking the resolution by the Region 4 Board as a template, or maybe your recommendation is going to be a bit different than that. If the regulated community is unhappy with this, the direction that it's going, what is their, or the decision that's made, what is their recourse?
Well, there's some pre-decisional recourse. So what we've recommended is that the executive officer retain broad discretion to refer any MMP matter to the board. So if the executive officer looks at it and says, you know, this presents a unique issue that I think the board should hear, or presents a fairness issue, or whatever it is, the executive officer will be able to pass that matter straight through to the board before it's heard. Also, the resolution will allow any board member, or potentially a majority of the board members, depending on how you want to do this, to pull the matter to the board away from the executive officer. So we want to make sure that there are safety valves to allow those MMP hearings where there could be merit to come to the board if necessary. Now that all sort of assumes that the executive officer is not going to be a fair hearing officer, but in most cases the executive officer is fully capable of being a neutral and impartial hearing officer, especially in the professional boards that we have today around the state. So, but there are those safety valves in the event the executive officer feels it raises a unique issue that needs to go to the board, or for whatever reason feels like the board should hear this, or from the board side, whether the board believes that it should hear it.
And then I presume that whoever makes that decision, whether it be the executive officer or the board, the community still has the right to petition to the state board. Is that correct?
Absolutely correct, yes. So there's still the possibility of review to the state board. And so here are some of the considerations that we've had here. And as you may know, and I think right after the state board issued some really important decisions on the availability of equitable defenses like latches, there was a hearing in this region, and we scrambled to get these last-minute papers in front of the board. But as you may remember, the state board really clarified the narrowness of the availability of those equitable defenses. And so, you know, in light of that precedent, that actually lends greater support to taking this approach, because the executive officer then is fully, I think, capable in most cases, and dare I say the vast majority of cases, of making a fair decision based on the state board's precedent and the legal precedent out there. So this is something that I'm just saying, watch for this, because I'm going to make a recommendation that the board agree to this. I think it'll save your staff and you a lot of time to work more on targeted discretionary enforcement in irrigated lands or wherever it is important, so that you can you know, focus that deterrent effect in a very proactive way.
I have to ask. So this is not news to you, Pamela, right?
Oh, he presented the white paper to, maybe I just chatted with Carl about, Dr. Longley about this. I'm sorry, I thought I had shared that with the board on the white paper Chris prepared on the MMPs. And the idea that, I mean, we have not had that many come to this board, but the ones that have took an entire day only for the board to say, we have no discretion. So it is a time-consuming process for something the board can do nothing about at the end of the day.
And so I take it you agree with this recommendation?
We have so few of them, I think it would be a great thing and a good use of our time and to save you time.
Well, our resources are so limited, and it's,
I mean, honestly,
Yeah.
if I felt it was something that was valid, I wouldn't hesitate to bring it to the board.
And can I,
I was going to say, so I've done some outreach with the governor's office, and I know there's been some encouragement from the governor's office for the boards to become more engaged with the regulated publics and the NGOs, the regulated public and the NGOs. And they actually felt like this is a really good idea that will allow the board to engage more with the regulated public on controversial or complex permits. And part of this came out of the Malaga MMP hearing that was heard by this board, where I know it was very difficult for this board to hear that matter. It was very difficult for me to sit in the audience and watch it, and I love this stuff. So it was one of those situations where it was finally like, we've got to be able to do something about this. So in addition to regulated outreach to the regulated public, I've talked to the keepers representatives, coast keepers and baykeeper, and they actually think it's a very good idea because they do want to see greater focus on discretionary enforcement. And I've also talked to Bobby Larson, who represents the, is it Aqua?
No,
Aqua?
no, it's the,
Oh.
now I forgot it. It's the
It's cost.
discharger, the
Right.
municipal dischargers, yeah.
And Tess Dunham, and they all feel like it's a good idea. So I've done a lot of outreach on this, and again, as long as we have this appropriate safety valves, so that an important case can get to the board, I think it's really a good approach.
So, Carl, can I say something?
No.
Right, you're pointing.
Denied.
No.
He reminded me
It's
of
just a
Malaga.
question of time.
He reminded me of Malaga, I'm sorry. By the way, it's CASA, California
yeah, CASA.
Associated Sanitation Agencies, yes, go ahead.
I see why this is important, and we were talking about safety valves and the way that the board can call these up. But my concern is for the regulated community. Okay, it feels like, and I'm just going to get this out there, and MMPs, I know there's nothing we can do about them, but it seems like if the regulated community, the discharger, only gets to talk to the administrative officer, okay, and then they appeal to the state board. And if the state board is coming up with regulations now where they're sort of summarily dismissing things that they believe have no merit, then the first time that this discharger is ever going to get a fair shake in front of a body is going to be at the writ stage, where we talked about that it really gets expensive. So I guess from the point of view of somebody sitting in the public, I appreciate that we have safety valves, but it doesn't really seem like, they're going to be that happy with this summary disposition. But
Two responses. First is, they will get a fair shake from your executive officer. I think I can say that with great confidence. The second thing is, and I'll put this out there, even though the Region 4 board elected not to do this, but as you know, sometimes in cleanup and abatement orders, there is an opportunity for discretionary appeal to the regional board. If that's the way the board would like to have it, then you could direct us and your chief counsel's office to build that into the resolution, such that a discharger would have a certain period to seek discretionary review from the regional board prior to filing a petition with the state board.
and I just want to say that I did mean to imply that they wouldn't get a fair shake in front of Pamela.
Bob, go ahead.
I did want to comment on that.
No, wait,
I
but
have
hold
a
on,
lot-
hold on, no, I'm not done though, sorry. I was saying that, I didn't mean to imply that, but I do think that in that same thought, that it might not feel to them
Well,
like they're getting the fair shot.
I have a question on that too, but go ahead, Bob.
And that's a good point. Law is the transparency is not only the letter of the law, it's also the appearance and spirit of the law. So I think that is a particularly good point. And also, when we're talking about executive officers in this, I think we want to avoid talking about our executive officer at this point in time, because there will be another executive officer, and we can't speak to that at that point in time. So.
And I say that not just because I know Ms. Creedon, but it's also because the executive officer really is a person with broad understanding of the board and how the board would react. The executive officer in each region is the only employee of the board. And so it would be more difficult if you were looking at it as someone who was a civil servant or someone who did not have that direct relationship with the board. And that's why I said it in the more generic fashion, Bob, even though I implied that I meant Pamela. I really do believe in the more generic fashion. This is the best person to undertake that role. But again, I think there are safety valves here that are necessary so that the regulated public has the amount of process that it's due.
I like what Carmen said too on this though, is how is there any appeal? And maybe that's just a written letter, or they can come do public speaking, or they can, maybe we write in here that they can appeal to the chair of the board, just so there is some other step that doesn't involve a board hearing.
And to me, that's a perfectly acceptable approach. It allows for the board to act efficiently and yet provide that transparency and that availability to the regulated public. Yeah. So certainly, again, I mean, that was my suggestion. I think that's something that provides a good outlet.
Wait a minute, Carl. On process, I assume this would come to us in a meeting or two for a hearing, and we'd do it in that way, and maybe we'd do it for a pilot year with, how did this go? Sort of analysis after a year or something.
Well, I think we always have the option of revising any of the delegated powers that we've given, but I would agree we need to come back and we need to discuss its efficiency at a point in time. And it's my understanding that since this is a delegated power, if you will, responsibility, that it can only be delegated to the executive officer and not to any other individual. Is that correct?
No, actually, yeah. Water Code Section 7 allows the executive officer to delegate any of the authority that was delegated to her to any one of her deputies. So that can be redelegated throughout. I mean, I think that it actually, this authority is currently within her authority right now. It's really just carving out the contours of whether we want them to go down that direction, whether we want to hold individual hearings. We have a very, very broad delegation doctrine, and I think that allows us to be very responsive. But before moving in this direction, I think the board would see a resolution in front of us. We'd also be talking about how many of them there are and whether it would be worth to create these additional procedures for these particular instances. We probably need court reporters, get those contracts underway, things like that. We really only have had a couple of these. Malaga is kind of the exception that proves the rule. I think there's only been a handful in the past 4 or 5 years.
Actually, I think Malaga should have been in front of us.
Dr. Long?
I'd like to add one point here. I didn't see you, David. In terms of the suggestion request, perhaps that there be some sort of informal appeal right to for these final mandatory minimum penalty orders for the board to consider subsequent to that action. There might be a legal obstacle to that type of approach. There's a statutory provision. I'm not sure if Chris has considered this yet, but that all ACL orders are final and effective upon issuance, and that the sole remedy for reconsidering that final action is through a petition to the state board. So that might pose an obstacle to this type of approach. So I just wanted to flag for
That's
further
an OCC
consideration.
memo. Yeah, I have considered that. It's in the chief counsel's office memorandum that doesn't consider this circumstance. So it's something I feel like we should be able to work with, but I would look at it more closely. But I did want to let you know, to Patrick's point, this region, and actually all the regions but 3, have a broad enough delegation where the executive officer could already do this. But we think it's important enough that we would want to bring a separate resolution so that the public was allowed to weigh in on it.
Right. And Dr. Longley, I don't want to put a too fine a point on this delegation issue, but just to piggyback on a comment that Patrick had made earlier, the statute already allows for the executive officer to do hearings for all ACLs. It's just that it's been the past pattern and practice of regional boards to bring those in front of the board for its consideration. So my own 2 cents is I think the proposal, as I understand it from the Office of Enforcement, is
Now,
very modest.
You bring up a point, and there are settlements on ACLs. But what you're talking about is a hearing where the executive officer would sit as the body, if you will.
That's correct.
And Carl, I think Dr. Longley, I think what they said is that it might not be the executive officer. It might be somebody the executive officer
Has
appoints.
delegated it to, yes.
So,
So she can go to Hawaii.
so we give you some
Absolutely.
thought problems today. Andrew and I thought, today it would be good to have you thinking about programmatic SIPs and the Rose Foundation, and instead of just information items, we're giving you thought problems and MMP recommendations.
Is there anything,
I had a general comment on enforcement, and, a lot of this is we do have these major egregious issues that we need to deal with. There's also small issues sometimes, and I think it's important to make sure that some of the, we don't want people to drop through the cracks, and I think it's important to have that in our consideration also. There may be issues that are just not so bad, but sometimes you just have to let people know we're going to treat everybody fairly, and you may not be a huge polluter, but if you're discharging illegally, you're still subject to our rules and regulations to protect the waters of the state.
and we have those in front of us from time to time, and they're very important.
The Socorro matter is one that comes to mind.
Right.
Yeah.
I'm sorry, I've been talking too much, I know, but I have one question that I want to ask in response to, I think, a theme that Board Member Ramirez had raised earlier, and it's a slide that's earlier in your presentation that talks about the amount of ACL, just the amounts themselves that have been assessed between '09 and 2013. I guess
Numbers or the number?
those
of
numbers,
actions?
that slide right there. Yep. So I guess the question in my mind, one is, to what extent do we know, for example, what percentage is in collection? Or what percentage of that amount is suspended, for example, because it's been petitioned to state board or it's under judicial review? Do we have any sense or scope as to what that is? And again, the only
we
reason...
don't, and I'm just trying to figure out whether we could get that. I can tell you right now, but this goes back 12 years, that there are $11 million in ACL penalties pending petition for review in cases that raise no unique issues.
Right. And
So I can tell you things like that.
Right, and I guess one reason I bring this up, and again, I'm not casting any aspersions on any other public agency within Cal EPA, but I think folks are generally aware of the fact that there's been a lot of press about DTSC and the amount of uncollected fines.
Yeah.
And to the extent that we've got some numbers in that regard, that may be useful for the board.
Okay, any further,
I would
thank you.
say too that the goal would be to have these numbers going down, meaning we have more compliance.
That's right, that's right. Any further comments?
But Dr. Long, if I could just say one more thing, and although I'm leaving as your lead prosecutor, but yesterday we had a case before you on the city of Sanger and the pollution, the groundwater. And part of my question to Lonnie and Clay afterwards was, how did we get to this point? And part of it is because of resources and not being able to look at the reports, and also the fact that we hadn't had them monitoring for nitrates. And it was only because they were monitoring for nitrates and they gave us the information that we knew about this. So I'm going to work with the EOs on this about what kind of initiative we can as part of the enforcement on what we need to do in order to get our facilities monitoring for nitrates and to start doing something to look at some of these SMR or the monitoring reports more thoroughly so we can identify these, so we're not coming to you after a pollution problem occurs, but we see it occurring. So I'll work on that as part of the emerging problems that he identified.
Thank you. I'd like to talk to you about that separately at the point that I have some ideas, but not here. Any further comments? Well, Chris, I want to thank you very much, and Andrew, I want to thank you very much for the 3 presentations. It's obviously this is something of great interest to the board. I might point out that after we had some very interesting ACLs in front of this board, we did have a meeting that was about 3 months ago or so with Chris, and Chris since then, I understand, has gone around and talked to other board chairs and so forth. But Jenny was there and myself and staff and talked about some of the past actions to see if we can become more efficient at how we handle these particular actions. I appreciated that dialogue, and I think it might be useful if from time to time the chair and the vice chair meet with with your staff, or with you in particular, to just, and of course, obviously, the executive officer and her staff, to review where we've been and what lessons might be learned there.
It's invaluable for me to meet with the board members directly, and I appreciated the meeting we had that day. It was very helpful. My staff is far too busy out working in the field, so it'll have to be me.
And it may well be that this maybe should be a WQCC topic. That's something we can explore too. That's a noticed meeting. We can raise questions and not worry about, a number of board members can be there, and we cannot worry about ex parte with, since that is a noticed meeting. Thank you very much.
Thank you.
We have about 15 minutes at the most. John, let me just ask the board about the item 21, the ex parte contacts in the general order. We talked about this before. Does the board have any issue? We're going to have a long discussion, then we need to move to voting. John has to leave very shortly to go downtown. If agenda item 21 is going to be very perfunctory, we can move ahead.
I'll just say that this was an issue that we've talked about in the past. I read the resolution and the sort of safety valve provisions, and I was fine with it.
Is there anybody else that has an issue with the resolution? Okay, at this time, the board will consider a resolution providing guidance for the 14-day blackout period on ex parte contacts regarding general orders. I'm sorry?
Real quick, there was a late revision that should have been, I think it was emailed to you, basically letting, that puts in the resolution that we will let you know if there are odd circumstances to a particular item.
But let me continue to say this meeting will be conducted according with the meeting procedures published with the meeting agenda. Following staff presentation, interested parties will be allowed 3 minutes. Are there any interested parties here? I see none. We'll now begin with the staff presentation. And do we need a staff presentation? I think we've been through this.
There is a resolution, and thus concludes my staff presentation.
Okay. Any discussion? I'll entertain a motion.
I'll move with late revision.
Do I have a second?
I'll second.
John's moved. Jenny seconded. All in favor state so by saying aye. Aye. Opposed say no. Abstentions? Motion carries. Now we'll
Sorry,
go-
Patrick.
Pardon?
I said, sorry, Patrick. He's probably ready for the hearing.
No, that was the extent of my preparation, so.
We now go to the last item of the day, and we have 2 hours on this item. So we'll be out of here. I hope we get out of here by 7 after 5. This is the election, and I'm just poking fun at staff that put 2 hours on this. And board members have been asking me, why 2 hours? Election of the chair and vice chair.
Maybe they were going to bring in a boxing ring. We don't know.
I think we should probably do these separately. And if Carl is willing to serve again, I would, for purposes of discussion, I would make a motion that we appoint or ask Carl to be chair for the following year.
I second.
Well, thank you. I'd be happy to serve. There's some issues that need to be taken care of that I think it gives me as chair a better role in. One of those, of course, is CV SALT. Has been ongoing forever since the beginning of time, and will probably continue to the end of time. But some important things are going to be happening, and I appreciate the confidence.
And I also, I like Dr. Long in that position, but having said that, I'd like to poll the rest of the board to see if anyone else has interest in serving as chair.
And that's why I said for discussion purposes, I'd make a motion.
this is a topic that has come up in my household and my brain many times, and I think I do want to be chair, but not this year. And so, there's a certain stature and ability to learn more and be involved and make policy that the chairman has the ability to do, where it's just that added extra information and decision-making capacity, and I will like to have that opportunity at some point. But that being said, this year, for a variety of reasons, is not the year, and so I would, I would even, unless someone else wants to, I would concur with Bob that Carl take the reins for one more year.
Oh, I'll just chime in and say that, yeah, it's something that I've thought about as well. I also, at some point, would like to be chair, but I think for this year, we have some great leadership at the helm, and I'd like to have one more year under our great leader's wing.
You embarrass me.
So at this point, not, but maybe for next year, I'd like to consider being chair.
And I'll just say that I care about what this board does, but I think that with the kind of life that I have with young kids and private practice, that I'm not anytime interested in being, and I mean that in a good way, in being chair, because I know the dedication that it takes. So
I hear you saying you have problems with other chairs, like high chairs.
yeah, I've got high chairs that I deal with. I don't need these chairs.
Yeah,
So with that, I'm glad to support Dr. Longley as the vice chair, as the chair for this upcoming session.
And I did joke earlier with the board that Bill Crook's kind words about Carl, and I wasn't sure if those were recommendations to continue as the chair or a eulogy. So I'll take it as a recommendation.
But I will point out that when Mr. Crooks was speaking, he used past tense. He did say Carl was a gentleman. Carl was a good person. Carl was a good leader. So I don't know what he knows about him now. But apparently Dr. Longley used to be a fine person.
Like I said, Carvin, you're in the wrong calling. For those who weren't with us at lunch, we thought that maybe she could be a comedian, but that's a different.
Yeah, look at the kind of audience I bring in. Look, I think there's 3 people.
Okay, any further comments? I think I'm going to close and call for the vote. All in favor, and I'll abstain. All in favor?
Wait, Dr. Long, let me just add a clarifying issue. Again, it's not a statutory requirement for the board to consider a vice chair. It's strictly just kind of custom of the regional boards. I don't know whether the board is
We haven't got there yet.
We haven't gotten there
okay,
yet,
thank
David.
you.
Okay, all in favor of the motion, state so by saying aye.
Aye.
Say no. Abstain, I abstain.
And moving on to a vice chair, which I do think we should have, I would recommend again, I'm not going to make a motion yet, but I'd recommend Jennifer, and again, a lot of that continues to be the interfacer we're having in our irrigated lands program over the coming year, and I think you provide a lot of leadership and credibility at this point in time that's pretty vital to this board.
And I certainly second your comments. I've seen Jenny in action. She has really moved into a major leadership role in the region, particularly with the agricultural community. And also with the marijuana community, I guess. I haven't been there.
Well, I guess I'll say the same thing I said before is, this is not a slight against anybody. I'm just kind of trying to poll to see who else is interested in the vice chair position. I'm not, but thank you.
I would be interested in the vice chair position. It was a position that I held the first year I was on board, and again, it brings with it added ability to be on chair, vice chair calls, and I get a better sense of what's happening as vice chair. I agree that Jenny has asserted herself and done a very nice job. So it's my desire to be vice chair is no slight to her at all. And I get that with Carl at the helm, many and most and all decisions sort of stop there. So, but since you asked,
I'm just trying to figure out who else would be interested, just out of fairness, because especially given now that this is an item that's going to be permanently on the agenda, it does sort of limit our ability to talk about things like this outside. So I think if this is the only forum where we get to sort of poll the board members to see who's interested, that's the only reason I'm doing it. I am satisfied with having Jenny. I think she's doing an excellent job.
You bring up a good point, Carmen. One of the things that John recommended, I think it's worked out very well, is doing this as the last item. For very apparent reasons. It allows the first thing in the morning on the first board meeting day, board comes in, and it's not really the best time to do it. So with that said, Bob.
Sandra has her microphone on.
Yeah, go ahead, Sandra.
I just want to say that I'm very glad to hear that Jenny and John are willing to wait a year and learn more, or listen more to the issues and go from there. But I would like to nominate Jennifer for vice chair.
And I'll second that. Any further discussion? All in favor of the motion state so by saying aye. Aye. No, say no. Opposed? Abstentions? And Jenny abstained. Very good. And it
I'll
is now
just
3:15:45, John.
thank you, Carl,
I
for.
said I'd try to get it over by
And
3:15.
when you have to go to an air board meeting at 4 o'clock on a Friday afternoon that people flew in for, it's not like I'm going out and partying. So I
Yeah.
appreciate that.